Have Professor Dr. Youseph Farah, Associate Professor, University of East Anglia, UK, enlightening us on the topic for today. I request Mrs. Rekha, Assistant Professor, Chennai Dr. Ambedkar Government Law College, Pudupakkam, to moderate the session. Over to you, ma'am.
Once again, thank you, HC ma'am. I take this privilege to introduce our next panelist, Dr. Youseph Farah, University of East Anglia, Norwich, UK. Dr. Youseph Farah joined the University of East Anglia in the year 2016 as a senior lecturer in commercial law. Previously, he was working at University of Essex, one of the top university in UK. His research interests focus on international sale contracts, investment arbitration, international commercial arbitration, and so on. He is the PG program director for the University of East Anglia Law School. He is also the module coordinator for international commercial litigation and the William C. Wiss with international commercial arbitration moot module. He has published several articles relating to international commercial arbitration, ADR and administrative law, corporate accountability since 2008. He also written a research handbook in European Union Private International Law. With this brief note, let me now invite our next panelist for the session, Dr. Youseph Farah, to share his knowledge on the topic, testing the impartiality of an arbitrator against the values of legitimacy and efficiency in international commercial arbitration. Sir, the forum is open to you, sir.
Thank you. Good afternoon, and I'd like to extend my thanks for the organizers for inviting me to talk today. And I also thank His Lordship Justice Sundar for a quite very good, interesting as well, quite informative speech about Article 34. The similarities with the approach in England is quite starking as well. I believe I have 20 minutes. I'm going to dive into this topic which I've chosen today, which is a subject of research I've been doing actually for 2 years. And I've completed a paper, and I'm just waiting impatiently for the decision of the Supreme Court in Chubb, Halliburton and Chubb, so that I could seal it and send it to for peer review. Now, can you please move to the slide 1, please?
Yes, sir.
Okay. So what I'll try to do in the next 20 minutes is to see how there is a constant challenge, almost tug of war between principle of impartiality and efficiencies of proceedings. These are two values very important for arbitration. And the issue of impartiality and independence, in fact, is not only important, but is of a very important constitutional value. Beginning with the main idea is that arbitrators must remain impartial and independent throughout the arbitral process. And then if you start to look at the various systems around the world, because really, despite the universal value and meaning of the principle of impartiality, systems express it differently. So you'll have a different expression in England than you would have in India, the US, France, and so on and so forth. So, for example, also under institutional rules, the duty is there. So you expect the arbitrator to remain impartial. Under ICC rules, you see that the arbitrator must remain independent. Arbitrator can be challenged for lack of independence or otherwise. You can see that there's no reference to impartiality, but there is reference to the independence of the arbitrator. But what really is important for me here is to try to understand the jurisprudential and constitutional foundation of the principle of impartiality. And I prefer to stick to impartiality because this is a language I'm used to in the UK, and I believe, and you will see towards the end, that the distinction is not that really stark. There's sometimes they are expressing the same thing. I mean, impartiality and independence. But let me just pause a little bit to reflect on the constitutional foundation of the principle of impartiality. And I'm using Article 6 of the European Convention on Human Rights. There is an equivalent provision under the Universal Declaration of Human Rights. And what Article 6 does is to say that when in the determination of the civil rights of a person and his or her obligations, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. So you see that this is a constitutional requirement that every party is entitled to a fair hearing and also to have his day before an impartial and independent adjudicator. Now, many might actually, say, well, this is actually, the reference here is to court judges or public officials and administrators. My argument would be is that what we are dealing here with is an unwaivable constitutional right. I mean, there will be instances where you could waive some of the effect or components of the doctrine of impartiality, but there will be instances where a red line cannot be crossed, so these are non-waivable. And also, importantly, I do believe that the arbitration also performs a public function and therefore will be also subject to these constitutional principles, even if they are expressed under international law or international conventions. So with that, I just want to remind the viewers or the listeners that despite this universal character of the duty of impartiality and independence, you'll find that it is highly jurisdictional, that, again, that it is expressed differently between jurisdictions. And I will try to highlight the approach in England, but towards the end, we'll also provide some discussion of how it's approached under other systems and under the IBA rules on the conflict of interest. Okay, so what is the challenge? Let's go back to my title, because the title is to test impartiality against the values of legitimacy and efficiency. And so I don't want to speak much about efficiency because I think we are all aware of the argument, how important it is to have a smooth functioning and to move the procedure forward, the arbitral proceedings forward, and that to have a final, like Justice Sundar said, that a very important value of having a final and binding arbitral award, and that arbitral award is to be enforced. I mean, these whole values are very important for efficiency, for cost efficiency, time efficiency, so on and so forth. But I think what is really under theorized in the discussion usually is the value of or the construct of legitimacy. Okay, so I don't think these are two separate constructs. I think they overlap from time to time. So you can see the more legitimate the process is, the more efficient it becomes. And I will show the instances where that manifests itself. But they do sometimes challenge each other. So, for example, the more lax the approach to the issue of impartiality, so the lower, the higher the threshold before you are able to remove an arbitrator or to challenge arbitral award based on impartiality, obviously, the more smooth the proceedings are going to follow. However, the outcome of the dispute might then be challenged on issues of impartiality. Let's move on a little bit, and then I'll come back to the issue of legitimacy, what I mean by that in a few minutes. Okay, so can we move to the next slide, please?
Yes, sir.
Okay, so yeah. So let's look at the relevance of impartiality under the English Arbitration Act, and English and Welsh Arbitration Act, really, I must say. It comes to life in various times of the arbitral proceedings. I mean, the Section 33, it provides a general duty on the tribunal. And one aspect of it, it states clearly that they need to act fairly and impartially as between the parties. giving each party a reasonable opportunity of putting his case and dealing with that of his opponent. This is none other than the whole principle of due process, or even, I would, well, not even, this is clearly part of what we might call procedural public policy as well, okay? So that is section 33. And then you have also section 24, where you are able to raise the issue of impartiality in order to remove an arbitrator for lack of impartiality. So that is also an important, where the issue of impartiality would arise. Can you please move to the next slide?
Yes, sir.
And then we, equivalent to the Article 34 of the ancestral model law, you could also challenge the validity of the arbitral award or request vacation or review of the award based on the issue of impartiality, as long as it could show that there was a serious irregularity and for failure by the tribunal to comply with section 33. That is the same section I mentioned earlier. So you could see that failure to comply with impartiality is going to shed an important doubt about the outcome of the dispute resolution. And that is obviously not a good thing for efficiency, because here you go, you've done all of that, you've spent all of the time and effort and money for dispute resolution, and then what you end up with is the product which is in a sense can be challenged, and that's not really good for efficiencies. Now, then the same issue of impartiality can be, again, it can be viewed as a procedural public policy in the context of recognition and enforcement of the foreign arbitral award under the New York Convention. So Article 5 there, which contains all of those grounds that allow challenge of the recognition enforcement, will become relevant. And 5.1, I see it as an issue of procedural public policy, but I also see it as an issue of substantive public policy, so falling under the remits of Article 5.2 of the New York Convention. Okay, so as you can see here, how the concept of impartiality is very important. The duty of impartiality is very important during the life of the proceedings, but also post the time when the tribunal is functus officio. Okay, can you move to the next slide, please?
Sure, sir. Is it visible, sir?
Okay. Where it's titled the construct of legitimacy, sorry, the following.
Sir, is,
yes.
Is it visible for you?
Sorry?
Sir, is the PPT visible for you, sir?
It is visible for me, but I think there is, I need the next one, the next slide. Yeah, okay. So then let's look at the construct of legitimacy. What do I mean by legitimacy? And I want to place it in the context of dispute resolution. It's, you know, let's look at it in these terms, that all grievance processes, in order for them to be legitimate, must enable trust from the stakeholder groups for whose use they are intended and being accountable for the fair conduct of grievance processes. I took this from United Nations Guiding Principles on Business and Human Rights, on Principle 31, which sets out the components of an effective remedy. So that is very important. It's how the dispute resolution process is viewed from those intended stakeholders, the users as well. And so, and we should not really view arbitration as an alternative dispute resolution. I've always rejected that description, because I think it is a little bit incomplete. Because I think arbitration is part of the civil justice system. It's very important for the civil justice system. And arbitrators perform a very important public function. Okay, and so this is why in England, for example, we view arbitration as the semi-judicial process. Okay, and therefore, again, containing all of those important public values, which I will come to in a few minutes. So what we need to then see how arbitration is viewed by those of interest in this civil justice, in this dispute resolution, this grievance process. And research suggests that this is empirical research, usually done in administrative arbitration, really, and other methods of dispute resolution. But what the research suggests is that parties are willing to place more importance on the legitimacy of the proceedings, the fairness of the proceedings, than on the outcome of the procedure. So the parties are more willing to accept the outcome of the dispute resolution if they see and perceive the process to be fair and impartial. So therefore, impartiality, as it will be seen in a minute, is very important process a component in making sure that the procedure is legitimate. Now so here what follows from this whole idea is of legitimacy is that, okay, so we need to ask ourselves, what is to say a process is legitimate? Okay, it's not a thing, therefore, in other words, it is composed of a number of constructs. Yet, one could argue is that the concept of legitimacy, the value of legitimacy in the traditional sense, is the property that a rule or an authority has when others feel obligated to defer voluntarily, irrespective of whether there is an external authority with powers to compel it to conform. Meaning that once we make sure that the grievance is legitimate again, parties are more willing to voluntarily comply with the outcome of the dispute resolution. And it's a wonderful thing for those who are active in the field of arbitration, that once we have an outcome and arbitral aware that the losing party will comply with it voluntarily. So leave aside Article 34 challenge, which is very expensive, and recourse to the court for recognition and enforcement, for example, under the enforcement system of the New York Convention. Can you move on to the next slide, please?
Yes, sir.
And now, I want you to reflect on another element, which is very relevant to the issue of legitimacy, is that the arbitrators, like judges, they perform an important public function. They do. Okay, again, arbitration is part of the civil justice system. It's very important for the civil justice system. And the reason why we have arbitration is because the civil justice system really has been inundated and under budgeted for many years, right? We say here in the UK that the civil justice system is under attack, right? So in the sense that, we would like to have more of court litigation, but we are unable to because it is lengthy, it is expensive, and obviously the docs are very busy. And therefore arbitration is taken away from that burden to deliver justice. But when a judge delivers justice, what they really do, for example, in the context of a civil claim, in contractual or commercial claim, what the judge is doing and the arbitrator is doing, they are restoring natural harmony. That's what they do. I mean, we see this in court litigation because the dispute resolution is transparent and the outcomes are published. We see this less in arbitration. But that doesn't take away from the main function of the arbitrator, which is to restore harmony, natural harmony. This is the work of the famous Professor Owen Fiss, who have written a lot on this issue. And I wholeheartedly believe in this notion. And when they do so, they express important values that are important to the public, okay? So what they do then is reflect a set of principles and assumptions, conscious or unconscious, about the appropriate distribution of risk, reward, and responsibilities between the different actors involved. The actors here are the dispute resolution, but not only that, but other stakeholders, okay? So what am I trying to get to here in this moment, in all of this discussion about legitimacy? Is that this arbitral dispute resolution transcends the private parties. Yes, it's very important for the private parties. There is that autonomy value, very important. It's a private party, if you like, and therefore it is important for the disputants, but yet it has wider implications. Arbitration has wider implications, and therefore the principle of impartiality is very important in order to push forward those legitimacy values constructs. And as you will see during the discussion, is that in fact, when we do so, we are also increasing the efficiency of the dispute resolution. So now I want to test it. I want you to look a little bit on how impartiality is measured and assessed under the European Convention on Human Rights, the ECHR, and also under in England and Wales and other jurisdictions. So can you move to the next slide, please?
Yes, sir.
Okay. So we've probably, many of us have heard this whole saying that that justice is not only done, but that it is manifestly and undoubtedly be seen to be done. This is very important because it increases the confidence in the integrity of the administration of justice and in turn in the perception of its legitimacy. This is taken from the case of Bray and Sussex justices from 1924, right? So it's very important. The appearance of impartiality is as important as having actual impartiality, right? And this goes to the heart of the text, that we measure, we assess impartiality, we safeguard that principle of impartiality by making sure that the arbitrator stays impartial, but also appears to be impartial. And this is very important for legitimacy again. Okay, next slide, please. So what is the test under the European Convention of Human Rights? I use European Convention of Human Rights, but again, this is almost identical to the Universal Declaration of Human Rights. There are many jurisdictions in Europe which adhere to the European Convention on Human Rights. So it is very important for all of those systems. And I think any test of impartiality in those jurisdictions has to be compatible with Article 6 of the European Convention on Human Rights. But again, this is my view. Obviously, this is debatable, slightly contentious, but that's my view. So in the case of Langberger and Sweden, landmark case on the issue of impartiality in relation to public official there, not an arbitrator, but public official, the test of independent, the court basically said independence must be seen from an objective point of view and impartiality from an objective and subjective standpoint. Just to remind you of Article 6 of the European Convention, which I mentioned earlier, it does include, it makes reference to impartiality and independence, unlike the English approach, which only uses impartiality. So in relation to independence, the court said that regard must be to the manner of appointment of its member and their terms of office, to the existence of guarantees against outside pressures, and to the question whether the body presents an appearance of independence. In the context of arbitration, really, when most arbitration is done via institutional arbitration, what we need to be looking at is the institutions and to see whether those institutions have those safeguards and guarantees to play in place to secure that independence, okay? So it's really an institutional assessment, objective assessment of all of those constituents of the arbitral process that are, you know, the conduct of proceedings, but also how you could how arbitrators are appointed, how they're challenged, and the internal safeguards of any institution that actually safeguard the impartiality of the arbitrator. But then we move to the test of impartiality, and there is a subjective and objective test. And the focus really with subjective is on the personal conviction and behavior of a particular judge or, again, arbitrator, while the objective test of impartiality is to assess whether the arbitrator, in our context, offers sufficient guarantees to exclude any legitimate doubt in this respect, okay? And so when we look at the subjective test of impartiality, it is almost presumed. Can you move to the next slide?
Sure, sir.
Yeah, sorry, I was ahead of myself a little bit. So just to, the test of impartiality, again, is viewed from a subjective and objective perspective. The subjective is to look at really what goes into the personal conviction and mind of the arbitrator, which is very, very difficult to do, really. And therefore, under European Convention jurisprudence, that is presumed, right? The arbitrator is presumed to be subjectively impartial. Okay. However, then the test become a little bit more interesting in ascertaining whether the objective element of the test of impartiality. Okay. And there, what we are looking for is appearance. This is a test, is appearance from the viewpoint of the public of whether or not the arbitrator is bias, basically. So there's a lack of impartiality. Can you move to the next slide, please?
Sure.
So then, okay, so this is the European Convention approach. Okay, what is the approach in England? Well, approach of England is very, it's not very complex, but it's a little bit confusing because this is because of the common law nature and the incremental nature of the test, because this has been developed by the judiciary for the past century or so. So it moved through different tests, often conflicting parallel tests when we measure and assess the impartiality of the judge. I just want to say here one point is that the test of impartiality of the arbitrator is the same that which is applied to the impartiality of the judge or any other public official or member of a jury, for example. Okay, so the case law that were delivered on the impartiality of the judge, member of a jury, or a public official, they are the ones which are used in order to assess the impartiality of the arbitrator. That was made clear in the case of Govt, 1993, in this famous speech of Lord Justice Govt. The earlier case we recorded on the impartiality of the arbitrator is the case of Dr. Bonham, and there what the court said that no one should be judge of his own cause. Well, that's a very simplistic view of the issue of impartiality. Of course, it's a lot more complex than that. But what we see under the jurisprudence of the English court is that the impartiality can be viewed in two overlapping spheres, if you like. Can you move on to the next slide, please?
Yes, sir.
So you could see that in relationship where the judge has a fiscal interest, monetary interest in the outcome of the dispute resolution, the same for arbitrators again, then the arbitrator should recuse herself or be removed, okay? And what we are looking for here is not a fanciful or trivial relationship, but doesn't have to be substantial as well, okay? And so where that is the case, and when we say fiscal now, it has been developed into other aspects. Is again trying to show a relationship between the judge and the outcome, whether they have an interest in the outcome. Okay, so like in the case of Pinochet, it was really extended to other than a fiscal relationship. For example, if you are a member of a trustee or a board member of a NGO that have fought for certain civil rights movement for many years, like in cases of Pinochet, that you have an outcome in the dispute as a judge, then that could actually be one of the tests. And I think here it's easier to remove the arbitrator, where you could show that relationship between the arbitrator and that there's an interest in the outcome of the dispute resolution. Can you move to the next slide, please? Then the other cases will relate to the second aspect of the ECHR test, is when we look at a test impartiality or the appearance of the impartiality, that objective test of impartiality. And here again, as I said, the jurisprudence of the English court took some time for it to crystallize. Now the main leading decision is the case of McGill, which I will come to. But prior to McGill, the test which was announced in the decision of Govt, I mentioned earlier, but then was Govt looked at a member of the jury, but then it was used in arbitration cases, the case of TNT Saudi Cable, and then Laker Airways, and there are other case law as well, but these are decisions by the Court of Appeal. The test was to ask really to having ascertained the relevant circumstances, the court should ask itself whether, having regard to those circumstances, there was a real danger of bias on the part of the relevant member of the tribunal in question, in the sense that he might unfairly regard or have unfairly regarded with favor or disfavor the case of a party to the issue under consideration by him. So here we have really, until McGill, this was a test which was applied when assessing the impartiality of a judge or an arbitrator or a public official or a member of a jury and so on and so forth. And if you look carefully on the test, what it does is, if you think about the yardstick against which you measure impartiality, you see what we are looking for is real danger. And in my eyes, a real danger is such a vague yardstick that could be anywhere between between possibility, probability, and even a higher standard that must be met. But I don't really care much about this yardstick. What really bothered me, and it continues to bother me, I'll show you why later on, post-McGill, is that in whose eyes should this test be applied? So is it in the eyes of the judiciary, or is it in the eyes of the reasonable person, or later you see the fair-minded? And you'll see that in Govt, the court said it's impartiality perceived from the perspective of the judge sitting, okay? Not the parties, not the reasonable observer, but rather the judge. And so therefore here there is a compromise to that whole objectivity, and also compromise to the legitimacy of the decision, because instead of including all stakeholders in the decision, so assessing it from the viewpoint of the stakeholder, and usually represented by the reasonable person as well as the parties and the judiciary and so on, we are assessing it from the perspective of the court. Now, if we move to the next slide, please. But so again, but to be reminded, England is signatory to the European Convention on Human Rights, and in 1998 they've also made it as domestic law under the Human Rights Act 1998, and and what they did is just repeat Article 6 of the Convention, and therefore the Supreme Court in the decision of Porter and McGill revisited the decision of Govt and said there is a problem in Govt because it doesn't really safeguard the objectivity of the test. It's not really objective because we are viewing impartiality from the Lord Justice's perspective rather than from the observer perspective. And so they are really refined the test. And they said now the test is whether the fair-minded and informed observer having considered the facts, would conclude that there was a real possibility that the tribunal was biased. So the question which is really interesting here is, who is the fair mind, right? We know that they've restored detached objectivity. So they are now closer as a jurisdiction to the jurisprudence of the European Court of Human Rights, and I think the jurisprudence of other jurisdictions, right? You'll see later in a minute, okay? Because that detached objectivity is very important for the test. But when I am still struggling to understand what we mean by fair-minded, the one case which is very interesting is a decision of Hello, which is again a Supreme Court decision, not on arbitration, but on the impartiality of the judge. And that was delivered post-McGill, so it's quite important. The court gave us a little bit of, some instruction of what they mean by the fair-minded. And to my dismay, we are really looking for really some complex, sophisticated character. That is a fair-minded. I don't think the fair-minded is a reasonable person, right? Or the lay person, or the lay person sitting on the omnibus in London, right? This is someone who is sophisticated. If you think about him, he's almost a creature of fiction, right? I know very, very few people in my life, including myself, which I don't consider myself fair-minded in most of the cases. But I mean, there are very few people who are going to be considered fair-minded. I guess that is a role reserved for the Lord Justices. Listen the language of the court in Hello. She is a type of person who actively looks for the relevant information or takes a balanced approach to any information she is given. She also puts whatever she has read or seen into its overall social, political, and geographical context, and appreciates that the context forms an important part of the material which she must consider before passing judgment. All good. She is not complacent or overly suspicious or sensitive, okay? And to the information received, she is someone who is able to distinguish between what is relevant and what is not relevant.
Sir, five more minutes, sir. 5 more minutes,
yes,
sir.
Yes, I'm nearly there. And weighs the evidence accordingly. So basically, if we move to the next slide, please. She is really a very sophisticated person, almost a fictional creature. So in my view, is that the court has compromised really, that restored objective assessment, but made it very, very difficult. In a sense that what we are saying here is that the judges will continue to assess. So the impartiality is assessed from the viewpoint of the judge rather than the detached, certainly not the reasonable person. Okay, so here are just few examples post-McGill. We could skip through these. If you want to move to the next slide, please. So these are all cases where post-McGill, the court removed the arbitrators because of lack of impartiality. Do you want to move on, please, to the next slide? Okay, now just a few words on Chubb and Halliburton. Here, I think quite a contentious decision because an arbitrator here failed to disclose an important fact that he was involved in an overlapping subject matter common only to one of the parties. So he was sitting as an arbitrator in other proceedings. Failed to disclose that. When it came to light, they tried to challenge the arbitrator, and the court said, well, there's no duty to disclose, but what really matters about the disclosure of that issue of the excuse given by the arbitrator, the explanation of why he or she failed to disclose. So this is under review now by the Supreme Court. We are impatiently awaiting a decision. I am personally, and hopefully we'll see what the court decides on that. My view is that in terms of application of the McGill test is correct decision, Chubb and Halliburton. I have problems with the McGill test because I prefer the reasonable person over the fair-minded person. But we shall wait and see. In my view also that duty of disclosure is neither here nor there. I think it can be considered as a serious irregularity, but that's another matter. But what really matters at the end of the day is to test the impartiality of the arbitrator, rather than to see, whether a failure to disclose in itself should be a reason for removal or vacation of the arbitral award. But in my view, if you are in doubt, there's always it's a good reason to disclose, because that also links to the issue of waiver under Section 72 in England, because that could waive your right to raise the same issue as the other party at the end of the proceedings. The next slide, please. And with this, I will finish. Yes, can you move on one more, please? Yes. Yeah. Okay. So just looking at the comparative jurisdictions quickly, you will see that, and I'm sorry, I don't have reference here to the approach in India, but I'm sure I'm keen to listen from my learned friends and from the other speakers or from the audience. But if you see the approach in other jurisdictions like Australia, there is emphasis on the reasonable person, right? It's detached objectivity in the eyes of reasonable bystander. The US, it's about evident impartiality, and there's inconsistency in the approach with the lower courts, but yet emphasis is on the reasonable person. In France, it's reasonable doubts. We are again employing the reasonable person legal construct when we assess impartiality. And most importantly, when we look at the IBA guidelines, which represent best international practice, you see also reference is to the reasonable third party. So with that, I would just like to sum up the speech by saying this thing. In my view, the issue of impartiality, again, it's a mandatory rule, it's a fundamental right. And using the Gospel of Matthew is very good here in this instance, that you can't have two masters, right? And I believe that the master in my discussion between efficiency and impartiality is impartiality. The due process at Article 6 of the European Convention of Human Rights and Article 10 of the Universal Declaration of Human Rights should be viewed as a master. But obviously, efficiency is very important, but yet it has to concede every time there is justifiable doubts about the impartiality of the arbitrator. This is a best practice, and in the long run, in relation to the arbitral proceedings, this is going to, in fact, increase efficiency and increase legitimacy, not only of the procedure and the civil justice, the arbitration as part of the civil justice system, but also the legitimacy of the outcome of the dispute resolution. Thank you very much.
Thank you, sir. Thank you for for widening our knowledge with respect to the impartiality of an arbitrator in international commercial arbitration. We are really privileged to listen to your speech, sir. Now we'll move on to the questions and question session. Out of many questions we have received, I have filtered a few questions. The first question is, sir. Sir, shall I proceed?
Yes, yeah.
Yeah. The first question is, sir, from Ghazala Noor, one of the participants. Her question is, what are the challenges faced by an arbitrator during foreign and international arbitration?
Challenges in
Yes,
sense
sir.
of, in the context of
during
impartiality.
the international arbitration. Yes, sir.
I mean, I will limit it to impartiality. Obviously, there will be many, many challenges in arbitration. By all means, arbitration is always described as an efficient, quick. Sometimes I hear this dispute resolution process, and there is a fallacy there. I mean, it's all well when there is that cooperative ethics between the parties, but if anything goes wrong, it becomes very expensive. It becomes very inefficient. I mean, there's like the case of West Tankers, for example, which related to the issue of anti-suit injunction. It took 10 years just to have a decision on the European level, and therefore remitted back to the national courts. So arbitration can be very complex. In the context of impartiality, I would say one thing is that sometimes you might have a clash of culture. I mean, you might have an arbitrator who comes from a jurisdiction which have a certain way of seeing an understanding impartiality than an arbitrator who comes from a system which might be a little bit more relaxed about this whole idea of impartiality. That would be a very huge challenge. But then what you need to have is a chairperson who is very strong, and that's very important in an arbitral process, but also institutional arbitration that are there to maintain the integrity of the proceedings.
Yes, sir. Thank you, sir. One more question, sir. Last question. It's a question from Vijay Kumar, Assistant Professor. His question is, if the arbitrator has violated the principles of natural justice in the process of legitimacy in the international commercial arbitration, what are the remedies available, sir? Shall I repeat?
Remedies against the arbitrator. Okay.
Yes, sir.
I mean, again, this is highly jurisdictional. Depends on how you see the role of the arbitrator. I mean, in many systems there is let's say a good degree of immunity. I wouldn't say it's absolute, but there is some immunity for the arbitrators, particularly in common law jurisdictions. If the violation was not, particularly if the violation was not deliberate, then and even reckless, then you won't have remedies against the arbitrator, but obviously you will have remedies in a sense if you see challenge of the arbitral award as a remedy, in the sense that vacation of the arbitral award, or you could use that violation at the time of recognition enforcement to ask a court seated with the request to refuse recognition enforcement. But in terms of civil remedy, much is going to depend on the jurisdiction. Some systems allow you to actually take the arbitration in a civil claim if they've done something reckless or deliberate. These are the systems that do not see arbitration as quasi-judicial, but rather place emphasis on the contractual relationship between the disputants and the arbitrator. And again, there will always be criminal implications. Some systems might attach criminal liability for breach of due process, particularly the issue of impartiality.
Yes, sir. Thank you so much, sir. Thank you for patiently answering the questions.
Thank you.
Yes, sir. And now I handed over the session to Hepsi ma'am. Over to you.
Thank you so much. Thank you so much, Professor Dr. Youseph Farah. Every session is like listening to Gary Bond lectures. Thank you so much. Now I request the next two panelists, Dr. Nathalie Najjar, followed by Mr. Inbavijan Veeraraghavan, to share their thoughts on the topic. I really enjoyed interacting with both the panelists as they were very cordial, and I'm sure the participants will benefit from their immense experience on this subject and the field. Now I request Mrs. V. Madhumita, Assistant Professor, Chennai Dr. Ambedkar Government Law College, Pudupakkam, to moderate the session. Over to you, ma'am.
Thank you, Hepsi ma'am. I'm very much happy and to introduce our third speaker, Dr. Nathalie Najjar. I'm very much happy and privileged to introduce our third speaker, Dr. Nathalie Najjar. She is an attorney at law and partner of Ibrahim law firm in Beirut, Lebanon. She is expertised in arbitration, both at domestic and international level. She is also a lecturer in charge at 2 universities in France and in Lebanon. She has been appointed as arbitrator with several international institutions such as International Chamber of Commerce in France, Cairo Regional Center for International Commercial Arbitration in Egypt, Dubai International Arbitration Center, and also she is an official representative of the Lebanese Republic at the International Center for Dispute of Investment Disputes. She also served in a wide range of posts such as General Secretary, Assistant Professor, Chairman, and also member of various international institutions. She also published many books and articles in her field, and she is also a recipient of various awards for her outstanding performance as an arbitrator. Ma'am, due to time constraint, I conclude with few details of Madam Najjar. I request ma'am to deliver a lecture on the topic arbitration and COVID-19. The forum is to you, ma'am.
Thank you very much for this presentation. Thank you for hosting me today. I would like to thank the organizers for inviting me to speak at this valuable semi-webinar. And I'm thank most especially Professor Habsiba Peter for her assistance all along these 2 weeks. And of course, the Dean of the University of Chennai and the University, of course. Thank you very much. I'm very humbled by your invitation. I will speak today actually on arbitration post-2020, the theme of the webinar, and COVID-19. More specifically, how did COVID-19 impact arbitration, and what may be expected in the future in this regard after COVID-19, given the hard times we have been living in and the globalization of this pandemic. First of all, allow me to say that like never before, arbitration appears to be the perfect method of settlement of disputes in these hard times, in such circumstances, because it relies on the autonomy of parties, on the very extent powers of arbitrators that have the ambition to manage and to deal with the complication that may occur in such circumstances. However, one should say that unfortunately practice evolves generally much quicker than legal frameworks and contractual stipulations. Generally, practice moves at a very quick pace, whereas legal provisions take time to follow up. Why am I saying that? Because actually what we have witnessed lately is that there is a boom, a sort of expansion, that has never been seen before, of online methods of communication. And these methods have been resorted to in many international disputes, in arbitrations, in order to deal with the COVID-19 pandemic. However, legal frameworks could be very outdated or that did not follow the pace of these new practices. I will give you a small example of that. If we examine the provisions of the New York Convention, Article 2.3 of the New York Convention recognizes only the arbitration agreement that is drawn in writing or by telegram or by exchange of letters. So you can notice very clearly here that the 1958 Convention is clearly outdated and does not deal with the very evolved methods of communication that we are dealing with today in our days. So it's very important to see, also to examine the content and the provisions of state provisions, of legal provisions in the countries where the arbitration held its forum. However, the provisions of this of the country where the arbitration is taking place is very important to examine. What would be the extent of the powers given to the arbitrators? How do they allow arbitrators to manage, to deal, to organize, and to confront complications in arbitration? And of course, what latitude, what extent do they give to the autonomy of parties also? Here, I would like to stress on the fact that today, given the broad expansion of the pandemic, it's now consecrated that the best way to deal with the COVID-19 is to allow parties and arbitrators to resort to virtual technology. and online methods in order to face efficiently time limits and to deal with distance problems, and more generally, the necessity of holding hearings and or complying with contractual or legal time limits. Precisely on this issue of time limits, many states have enacted legal provisions in order to suspend, to stay, to give some moratory, in order to postpone time limits, to face COVID-19, the COVID-19 pandemic. And that for filing lawsuits, for filing applications, petitions, appeals, etc. Given these 2 points that are very present while dealing with the COVID-19 issue, I will divide my lecture today into 2 different sections, The first section will deal with the impact of COVID-19 on arbitration internationally, worldwide, and what should be the remains of this pandemic worldwide in the future. And the second part will have, in the second part, I will have a quick look on the problems that India is facing while enduring the COVID-19 pandemic, because I examined the Indian, and based on the examination, the scrutiny of the Indian Arbitration Act, because it's clear that here again, some issues could be reported punctually. So what about the international status of arbitration with regard to the pandemic, and what print does this pandemic will leave on the future of arbitration after 2020? Well, first of all, let me tell you that it's now widely accepted that COVID-19 is being considered as a force majeure, or at least a hardship that would allow some reconsideration of mutual obligations. However, the impact on arbitration, of course, if the conditions are satisfied, this is for sure. But the impact of COVID-19 on arbitration is slightly different, because arbitration is a procedure, it's proceedings, and can be impacted differently. First, we should know that most arbitration and international arbitration have palliated the effect of COVID-19 by allowing parties and arbitrators to resort, as I said, to online methods of communication. Hearings are now very commonly held online on platforms like Zoom, like Microsoft Teams, and there are so many others. If you examine the guidelines that have been sent by the ICC, the National Chamber of Commerce, you will see that the ICC refers to the Wikipedia page of virtual communication, and it's listed there. There's at least 15 or more platforms that are the equivalent and even safer than Zoom, as I will be saying, dealing with this issue later on, to communicate virtually and holding hearings and video conferences. So this is becoming very common practice. And even the ICC, the International Chamber of Commerce, has issued guidelines in order to advise the practitioners to deal with the COVID-19 pandemic by resorting to virtual technology in order to hold hearings with parties, with experts, with witnesses, and more generally to substitute the the physical presence by virtual presence while the pandemic was still on. So this is very important to see that virtual technology is now gaining so much audience, and so much it's booming in local practice in arbitration as such. of course, holding a virtual hearing and dealing with these kinds of technologies is becoming a very acute necessity. However, now it's very important to say that it becomes very important while appointing an arbitrator to make sure that this arbitrator knows how to deal with the technology. Why am I saying that? Because I myself had experienced arbitrations, and not far ago. A few weeks ago, I had an arbitration with a former judge. He didn't know he didn't know even how to check his email. This is something that is absolutely unacceptable. Technology has become a part, an indissociable part of arbitration and of international arbitration. Methods of communication is of a prime importance, and the ability to deal with these kinds of methods of communication is a prerequisite now while appointing an arbitrator. So this is a very important point. But there is also a very important point, is that it's also very important to resort to a very safe platform of communication. Do you know, for example, that the Zoom platform that we are using now is a platform that allows the host, Zoom, while adhering to its conditions once you subscribe to Zoom, well, they allow the host, Zoom, to record whatever is being held on the platform, to keep a recording of these sessions, and they can they can use these recordings in a way the way they sees it appropriate. There is absolutely no control on this. So you know, and this is a very delicate issue, especially that we know that confidentiality is of prime importance in arbitration in general, worldwide. There's so many laws worldwide, and of course in India, as we will be seeing that later on. But there is also a very important issue to stress upon, is that it's also very important to make sure that parties have equal chances and opportunities to connect to the internet. It's not a given fact, first, that everyone has access to internet, and if someone has access, it's not obvious that all parties have an equal quality of connection to the internet. The same broadband could be, some parties can have a less efficient broadband than some others. This could affect the rights of defense, the rights of the obligation to treat parties on an equal footage. So it's very important that to make sure that that parties have equal chances to connect. That's why, for example, the ICC, the International Chamber of Commerce, stresses on the fact that the arbitrator and the parties conclude what they call a cyber protocol in order to set these prerequisites before going further on with the arbitration. So technology has become a very important issue in arbitration, especially on the light of the COVID-19 pandemic. Now, what will remain of this pandemic? Well, there will never be the same way of dealing with arbitration before and after COVID-19.
No, ma'am, you can continue, ma'am.
Sorry, yes. First of all, now it's very important to know that it's becoming common knowledge that whenever there's a way of avoiding costs of a trip, or transportations, or accommodations, or rental of business rooms or whatever costs, while while going personally to a hearing, whenever it's possible to avoid these expenses, well, the arbitrator should make his best to hold a virtual hearing instead of setting a hearing where the physical presence is at stake. It's becoming the duty of the arbitrator to see when is it possible to avoid a trip and costs by holding a virtual hearing, and when is it possible and when is it necessary to hold a presential hearing. Why am I saying that? Because sometimes it's important to say that sometimes in arbitration, the physical presence is also very important. Sometimes, for example, when you examine parties, witnesses, or experts, it could be very tiresome and very exhaustive to hold virtual hearings when we know that, for example, we should be assisted by translators. It could take hours and days of hearings and examination and cross-examinations. A record should be transcribed of the sessions. All that could be very exhausting if it's dealt with virtually. So it's becoming now very important to know what kind of arbitrator we should be appointing. Someone that should be keen and should have enough intelligence to deal with these complications efficiently. So this is becoming a very important issue. But there is not only the issue of hearings in arbitration. The hearings did not really raise significant problems. It only raised problems whenever one party was objecting on holding virtual hearings. And this is up to the arbitrator to deal with this situation. But sometimes the deadlines were affected, the agenda was affected, and here again, it's the role of the arbitrator to deal with these issues and to manage the arbitration in such a way as to move forward efficiently without sacrificing the rights of the defense of the parties. But there is also the problem of the award, the drafting of the award, the enforcement of the award. All these issues could raise significant problems after COVID-19 and under COVID-19, because not all law provisions worldwide have efficiently dealt with the virtual means of communication, namely at the post-arbitral phase, at the stage of the enforcement of the arbitral award. I will deal with this particular issue while examining in my second part the situation in India. I will, of course, I will not be exhaustive whenever dealing with India because I'm not a specialist in Indian law. But however, I examined the situation, first of all, with regard to the provisions of the Indian Arbitration Act, and I have examined some decisions and rendered by the Supreme Court of India and some governmental decrees. Yes. Yes. Yes.
You can proceed, ma'am. You can proceed.
Yes,
there was
thank
some
you.
disturbance. Yes.
Sorry, excuse me. First of all, so the problems that India will face or is facing during and post COVID-19 under the light of the provisions of the Indian Arbitration Act. If we have a look on the provisions of the Indian Arbitration Act, we may notice that this act goes back to 1996, and the modifications, the reform of 2019 did not address the issue of technology in arbitration. We may notice then when it comes to arbitration agreement, for example, the Arbitration Act requires that it be drafted in writing or in any method that provides a record. The same provision also exists in what relates to the methods of communication in the arbitration process. There should be means that provide a record of the receipt of the communications. So these provisions may raise some questionings as to whether an online communication is considered as a method that provides a record of either the communication or the arbitration agreement. So this issue could be sensitive. We should know that what is meant by the requirement, that means, I know that the Supreme Court of India was very open to online methods of communication and has rendered decisions that were very that allowed to resort to these kinds of methods. However, what is enshrined in the law is much more delicate. So this is something that could, as I said, raise some questionings. But in general, the Arbitration Act, Indian Arbitration Act, recognizes the powers of the arbitral tribunal to manage the arbitration in the manner it considers appropriate. So this, combined with the Supreme Court opening to online means of communication, could lead to, for example, to the possibility of holding virtual hearings on platforms such as Zoom or others. But what the problem is that this opening to virtual means of communication could stop only, could be limited only to the hearings, because if we examine the provisions of the Arbitration Act, we may notice that, for example, when it comes to the arbitration award, the arbitral award, an Indian Arbitration Act requires that it be signed and rendered in writing, which may give rise to some problems in practice if it's rendered virtually. And at the post-arbitral phase, I don't know whether it's compatible with the Indian Arbitration Act to enforce an award that is rendered virtually without being presented on a support.
I'm very much sorry to interrupt you, ma'am. Last 5 minutes, ma'am.
No, I'm nearly finished.
Thank you.
Yes, no need to. I complied with my 20 minutes given to. There is one additional problem also, the time limits. I have noticed that in India there has been extension of time limits, and the moratorium that has been given by decree of the government of India in order to file lawsuits, appeals and petitions and applications. However, contractual time limits are not dealt with within this decree. So this also may raise some problems. So at the end, what we can say is that at the very best, given the broad powers that are given to other arbitrators, hearings may take place on an online support. However, when it comes to issues like drafting in an arbitration agreement, communicating with parties, drafting an award, enforcing an award, all these issues can raise significant problems nowadays in India, but it's also something that raises problems also in so many other countries. I was giving a lecturing a while ago in different other countries, and they had the similar problems. So what we should look for after COVID-19 is to try to reform the system in order to be compatible with online means of communication. And this appeal to reforms is, of course, concerns India, but should go also further and should also concern so many other countries to be compatible with the problems we are facing today. Thank you.
Thank you, ma'am, for your wonderful lecture. Now I proceed with the first question, ma'am. So one question from Manisha, ma'am. She's asking, so resolving a dispute in arbitration is itself an agreement. So no one expected this pandemic condition, ma'am. So what if one is not willing to come in online, ma'am? Will you be able to compel them in this situation?
Exactly. This is a very important issue, because when the rights of defense suppose that you should be heard, that parties be allowed to be heard. What is a hearing? If someone objects that a hearing cannot be held virtually, could we say no, the most important is to be heard, whether virtually or physically? This does not have an importance. But in my point of view, we should not distinguish what's the method to allow a party to be heard. A hearing is a hearing, whether virtually or personally. But if someone objects on using online because of, for example, for discrimination between parties, and because they are not put on an equal footage, this is a very valuable objection. If parties have not access to internet, if parties have not sufficient broadband that's sufficiently efficient and strong enough to connect, all these issues could have a very high importance in arbitration. Of course, this is a very important issue, and it's important that the law deals with these issues and the arbitrators deal with the issues efficiently.
Thank you, ma'am. Another question, ma'am, is from Saju. He's asking, how will you be able to handle the emotional things of the parties via online, ma'am? Is that easy, ma'am?
It's exactly, this is a very important issue too, because actually when you have a personal hearing, when the persons are present physically, when you can notice so many issues in their looks, in their way they behave, in their way they speak, in the way they treat the other party, the way they speak with the arbitrator. So many issues are perceptible in a physical hearing that are not apparent on a virtual support. So that's why this is the importance of resorting to arbitrators that should know how to deal with arbitrations, with these issues, when to decide there will be a virtual hearing. And of course, I am against the idea of holding a purely virtual in common situation, not if parties agree on that and they have already settled the issue, but if it's something that's subject to objections, it's very important to know whenever to hold virtual hearings and whenever to require the physical presence of the party. This is very important.